Welcome everyone to our webinar this morning on preventing sexual and gender-based harassment, your WHS legal duties. So my name is Joel Hayden and I'm a practice leader in LegalVision's employment team, and my co-host is Amelia Diskoris, who's a lawyer in our firm. Before we begin, a couple of quick housekeeping items. You'll receive a copy of the slides we use today and a recording of the presentation, so there's no need to be taking notes throughout. You can submit your questions through the presentation screen and we'll try to get to as many of them as we can at the end as possible. And we would really appreciate it if you could complete the survey at the end to give us a bit of a feedback on the presentation. In addition to this, for the next 48 hours, you are also eligible for a free consultation with LegalVision to discuss how we can help your business. If you want to take us up on that, please provide your contact details in the survey at the end of the webinar, and we'll be in touch. So today, we will be discussing how to prevent sexual and sex-based harassment in the workplace, and we'll be covering off what an employer's legal obligations are, a specific understanding of what constitutes this conduct, including some examples, and addressing a relevant framework for presenting this conduct and some practical steps every employer can take to support that. And let's start by getting an understanding of what an employer's legal obligations in preventing sexual and sex-based harassment actually are. All jurisdictions in Australia prohibit this conduct in the workplace, with some of those provisions being found at the state level under the various WHS laws, and others being at the federal level, such as under the Sex Discrimination Act and the Fair Work Act. Those laws that I've just mentioned are the three main pieces of legislation that prohibit this conduct, so it is worthwhile touching briefly on each specifically. Under each state's WHS legislation, a person conducting a business or undertaking, or a PCBU, has certain obligations to prevent harassment. The state laws are largely standardised with the exception of Victoria, which still has very similar terms, with the concept of a PCBU being a broad term used throughout that legislation to describe all forms of modern working arrangements, which we can really understand as just being anything that is a business. A PCBU can be an individual or organisation and must ensure, so far as is reasonably practicable, workers and other persons are not exposed to risks to their psychological or physical health and safety, including risks from psychosocial hazards such as sexual and sex-based harassment. A PCBU must eliminate health and safety risks at work, or if that is not reasonably practicable, minimise those risks so far as is possible. A range of other duties apply to managing the risk of sexual and sex harassment, such as duties for consultation with workers and the duties of officers, workers, and other persons in the workplace. If a PCBU has management or control of a workplace, they are also likely to have additional duties under WHS laws that extend these obligations as well. And as you can probably tell by the way we have described these duties, they are very general and broad and are meant to capture a wide variety of risk to workers that extends far beyond just the harassment we're specifically addressing today. The Commonwealth Sex Discrimination Act, or the SDA as it's referred to, also includes a positive duty to prevent harassment and other related unlawful conduct. This operates concurrently with the WHS duties I've just mentioned. PCBUs must take reasonable and proportionate measures to eliminate as far as possible discriminatory conduct and that harassment conduct that we've also referred to. And as we just mentioned, that does extend to other general sex discrimination matters and victimization in relation to making complaints about that type of conduct. So specifically, a PCBU must eliminate, as far as possible, the unlawful conduct I've just mentioned in relation to not only themselves, but also workers, the PCBU's agents, and in some circumstances, third parties such as customers, clients, and suppliers. It is really important to note the positive nature of this duty. This means it is not enough for an employer to be reactive to these issues as they arise, but they must also be proactive in addressing these risks before they actually result in offending conduct occurring. Given the conduct today's webinar is focused on, it's also very important to note that where the SDA is contravened, an employer will have vicarious liability where their employee engages in this conduct and they have not taken reasonable steps to prevent it. And that means someone who has been a victim of that conduct can pursue the employer for the actual contravention of the act, not just the other individual who engaged in the conduct. The Fair Work Act has also been amended relatively recently to prohibit sexual harassment in connection with work, including in the workplace. These changes expanded the previous protections around prohibiting workplace discrimination and, like the SDA, provide that an employer will be vicariously liable for the actions of their employees if they haven't taken those reasonable steps I mentioned before. Now,
what is sexual? Thanks, Joel. I'll just get into some definitions of what is sexual and gender-based harassment. So given the very serious prohibitions on this conduct, it is important to understand specifically what is meant by sexual harassment and sex-based harassment. Sexual harassment is defined under the Sex Discrimination Act as any unwelcome sexual advance, unwelcome request for sexual favours, or other unwelcome conduct of a sexual nature, in circumstances in which a reasonable person, having regard to all the circumstances, would anticipate the possibility that the person harassed would be offended, humiliated, or intimidated. How is this different to sex or gender-based harassment? Harassment on the ground of sex is different as the conduct need only be connected with a person's sex or a characteristic that pertains to their sex, and the conduct must be of a demeaning nature as opposed to a sexual nature. So while both concepts obviously concern harassment and are generally required to be unwelcome, they are differentiated by one being about conduct of a sexual nature, while the other needs to relate to the gender of the person and be demeaning. Sexual and gender-based harassment can be a one-off incident or repeated behaviour. The most serious acts, such as sexual assault, may constitute a criminal offence. It can be obvious or subtle. Examples of sexual harassment include actual or attempted sexual assault, unwelcome advances, inappropriate physical contact, including unwelcome touching, hugging, kissing, and sexualized comments about a person's appearance or clothing, or derogatory comments because clothing does not conform to narrow gender norms. Sexual harassment differs from gender-based harassment, and some examples include physical assault, abuse, or threats targeted at an individual because of their gender, derogatory, offensive, or demeaning comments about a person because of their sex, sexuality, or gender, and excluding a person from training, promotions, or opportunities based on their sex, gender, or sexuality. It's important to note that the intention of the alleged harasser is not relevant. And in relation to sexual harassment, the harasser does not need to be sexually interested in the person or necessarily aware that their behaviour may be perceived by a person to be sexual in nature.
So now that we understand what specifically sexual and sex-based harassment is, we're now going to turn to addressing some strategies and recommendations to be able to prevent it from happening in your workplace. And as you can see on the slide there, the Australian Human Rights Commission, which is one of the relevant regulators in this area, and they're often called the AHRC, has developed a framework of 7 standards for workplaces to address sexual harassment from prevention to response. And given it's the regulator's view that these are very positive steps to take, it's a great place to start for addressing this conduct as an employer. And so those 7 standards address leadership, culture, knowledge, risk management, support, reporting and response, and monitoring, evaluation, and transparency. And we're going to walk you through these key standards and some examples of some considerations that employers can take on to try to achieve what the AHRC wants you to achieve in relation to them. So the first standard in the framework is leadership. Leaders have a crucial role to play in creating safe, respectful workplaces. To prevent the risk of harassment, leaders should be visible and proactive in their efforts to address these matters. They should challenge inappropriate conduct, promote positive behaviour in the workplace, and be transparent and realistic about any risks in the organisation. Leaders should keep up to date on knowledge about their role and responsibilities regarding the positive duty and under WHS legislation, understand the drivers and impacts of relevant unlawful conduct, know how to identify and respond to this conduct and where to go to for advice, information, and support if required. And that might include reading guidance published by the AHRC, reviewing relevant industry-specific research or reports, and attending seminars and training that can address knowledge and strategies for how to deal with this in the workplace specifically. The second element of the 7 standards for preventing harassment relate to the culture of an organisation. It's obvious that the culture of an organisation is a critical factor in determining how it addresses unlawful conduct. There is research that has been completed by the AHRC that shows that if a culture is toxic, it doesn't actually matter if policies and procedures are in place encouraging compliance and people coming forward to address this behaviour. The workforce still won't speak up if it doesn't align with the actual culture of the business. There are many strategies to build a positive culture that supports prevention of sexual and gender-based harassment. And for example, that could include regular team building and social events and access to senior leaders for all employees. Organisations can prioritise and support gender equality and diversity by paying close attention to gender balance and diversity in recruitment processes and pay and positions within an organisation. For larger organisations, this could also involve developing a comprehensive gender equality strategy, including relevant targets that they aim to meet, and a really robust policy and process around that, and assessing their performance against their results. And really, all of this is with the goal of encouraging employees to feel that they're in a safe workplace and feel comfortable reporting any relevant conduct that is likely captured by the laws we've been talking about. The third standard is knowledge, and this relates to workplace education and training and getting an understanding to all employees of what sexual and gender harassment is and how to prevent it and respond specifically within the organisation. This can obviously assist on a number of fronts, and it can demonstrate an employer's commitment to addressing harassment and can initiate change by developing a collective understanding of the expectations for behaviour within the organisation. And to be effective, this training should be mandatory for all new and existing workers. It should be part of a broader commitment to cultural change and gender equality and diversity. It should be demonstrated and role modelled by leaders within the organisation, and it should focus on developing behavioural skills in all employees.
The fourth standard is risk management. This standard is concerned with recognising that harassment is an equality and health and safety risk. To achieve this standard, employers are encouraged to take a risk-based approach to prevention and response. A risk-based approach involves regularly identifying and assessing the risk of relevant unlawful conduct occurring, as well as the impact that it might have on the health and safety of those affected. Implementing effective control measures to address those identified risks, and regularly reviewing control measures to determine whether they remain effective and appropriate in controlling those risks and making adjustments where required. Some recommended strategies from this perspective include limiting or not offering alcohol at work events, ensuring that internal and external lighting provides good visibility in workplaces, including in car parks, preventing public access to work areas when people are working alone at night, for example, via a security card or code, or asking guests to leave the room while work is clean in a hotel, for example. And finally, avoid sexualizing employees or the workplace. Support is the fifth standard in the framework for addressing sexual harassment and is especially important where the unlawful conduct has already occurred. Support as a standard is concerned with employees ensuring appropriate support is available, including for leaders and managers who experience or witness the relevant unlawful conduct. As a part of this standard, employees should be informed about the available support and how to access it, regardless of whether they report the conduct themselves. Practical steps to achieve this standard include providing internal support avenues, such as designated managers and HR personnel. Certain employees may be appointed and trained as support contacts, for example. Liaison officers and peer support groups would also work, as they can be trained to receive disclosures of unlawful conduct. Employers should also look at providing specialist external support services with specialized knowledge and training in handling such harassment matters. Reporting and response is the sixth standard and involves ensuring appropriate options for reporting and responding to unlawful conduct are provided and regularly communicated to employees and other impacted individuals. Responses to reports of relevant unlawful conduct should be consistent and timely. They must minimize harm to and victimization of people involved. Consequences applied must be consistent and proportionate. The key points in addressing this standard are having clear reporting mechanisms that are actively promoted within the organisation, responding swiftly and appropriately to reports to reduce adverse impacts, and applying fair and uniform disciplinary actions proportionate to the misconduct. Monitoring, evaluation, and transparency is the final standard of the 7 standards. To meet this standard of the framework, an organisation should collect relevant data to understand the nature and extent of harassment within the organisation. They should then use that data to assess and improve the workplace culture, as well as to develop strategies for preventing and responding to harassment. This standard requires transparency from employers about the nature and extent of reported behaviours that could constitute harassment concerning their workers and actions taken to address it.
Now that we've explained those 7 standards, and there is a lot to unpack, obviously, with all that criteria we've provided, we're going to give some suggestions on our key takeaways for what a business can actually implement from today's session in your own workplace. And a key point to be aware of is what is reasonable and proportionate for any individual business will necessarily depend on factors such as the size, sophistication, and nature of the industry it operates in. But we think there are some steps that almost all businesses can take regardless of their size. And frankly, they're steps that should be taken to ensure there's compliance with these laws and the positive duty. And as with any risk in the workplace, it's important to properly assess and identify circumstances which may lead to higher risk in any individual organisation and develop policies and procedures to address that. And examples of risks that may be relevant in the context of today's presentation are things like a lack of diversity, gender divisions, power imbalances such as significantly hierarchical structures, isolated work, and consumption of alcohol in the workplace, and of course, any organisations that have prior issues relating to harassment of this nature. At a minimum, a business should ensure that it has appropriate policies in place to prevent sexual and gender-based harassment. And from a compliance perspective, we recommend all businesses should have an anti-discrimination, harassment and bullying policy, which describes what these behaviours are and prohibits them. This policy can also explain the method by which an employee can raise a grievance in relation to an alleged breach of the policy. An equal employment opportunity policy, which should address the company's commitment to ensuring that all employees are given equal access to training, promotion, appointments, and any other employment-related issue without regard to any factor not related to their competency and ability to perform their duties. And a WHS policy, which identifies and addresses any specific risks to WHS in the relevant workplace. And this might be where employees performing work at client sites or dealing with customers directly, and giving clear guidance on how these risks can be specifically managed. And while policies are useful, having policies alone is unlikely to be enough for employers to meet the new positive duty. It's recommended that proper training and education on preventing such harassment at work is also provided to employees. This vital step covers various aspects of the 7 standards, including culture and knowledge. It educates your staff on recognising what sexual and gender-based harassment looks like and how to report it within your organisation. As a step further, an employer may also provide tailored training to employees based on their seniority and role within the business. Senior leaders, in particular, shape the workplace culture and are likely to receive related complaints. They need more comprehensive training on their responsibilities to prevent harassment and ensure their teams understand the same. Employers should also consult with employees in relation to these matters, and that's also a requirement under WHS legislation specifically. And we recommend utilising mechanisms such as anonymous engagement surveys, which will assist with identifying any shortcomings in the culture of the workplace. For example, some questions that could be asked under such a survey is, in the last year, have you experienced any unwelcome behaviour which may amount to harassment? Would you be comfortable raising a complaint about these matters in the workplace? Are you aware of the appropriate channels to raise a complaint? And how committed do you believe that your leaders are to fostering a culture of transparency around equal employment and related matters? And finally, it is vital that businesses continue to stay up to date on any new obligations imposed and continue to reassess their approach to managing risk in the workplace from this perspective on an ongoing basis. This way, all employees can work towards maintaining safe, respectful and productive workplaces, which is really the intention of all these laws that we have been talking about. So that concludes the substantive portion of the presentation today. So now I'll pass back to Amelia for some questions and to wrap us up.
Thanks, Joel, and thank you everyone for listening in today. You might find our publication on how to hire and inspire useful in developing organisational culture, which can be downloaded from the slide on the screen now. You might also be interested in our upcoming event, Protecting Your Retail Business, Understanding Your Legal Obligations, which is on Thursday, the 2nd of May at 11 a.m. We're going to answer your questions shortly, and while you submit them, we'll take a minute to tell you about LegalVision's membership. By becoming a LegalVision member, your business gets unlimited access to our full team of 100+ specialist lawyers for all of your business as usual legal needs. It's like having your own in-house counsel for a fraction of the cost. Our team can assist you with unlimited document drafting and reviewing of business contracts, unlimited legal advice consultations, and unlimited domestic trademark registration, and much more. We also offer a dedicated service for in-house teams and general counsel to manage your high volume business as usual legal tasks. To learn more about how our membership can help you, request a free consultation when the survey appears at the end of this webinar. So now we'll answer some of your questions. I can see one here for you, Joel. Should a sex discrimination policy be separate from anti-discrimination, harassment, and bullying policies?
It doesn't need to be separated out, and given the relevance of sexual harassment and sex-based harassment to discrimination and general harassment and bullying policies, it really makes the most sense to have it included within that policy. And really, it's not so much about where the policy sits anyway. It's about it covering off the key points of what is the behaviour that shouldn't be occurring in the workplace, what are the relevant sources of law that relate to that conduct, who can be held liable for that conduct, and that's the individual contravener as well as the employer, and providing a mechanism for a complaint to actually be made. And as with all policies, the most important point is employees actually need to be made aware of it. It's not a piece of paper that should be sitting in a desk somewhere, never seen. It should be provided to all employees and really from time to time updated on with employees to ensure everyone's aware of their responsibilities there.
Yeah, that makes sense. We've got another one here for you. Do you recommend a complaint procedure for sex discrimination that is separate from a grievance complaint procedure that exists for any other workplace complaint? If so, what, how, and should it differ to make it more specific or tailored for a complaint related to an incident of sex discrimination or gender-based harassment?
And so it can be good to have a slightly different procedure than a usual grievance policy, in that given it often relates to more serious matters than, say, general work-related grievances, it's good to have more options as far as where to report it. So an employee who suffers this kind of conduct, they may not want to speak to someone of the same sex or of the different sex either way. They may not want to speak directly to their manager or anyone who knows them personally. And so it could be a good differentiating way to treat a complaint for sexual harassment related matters, to have a few different reporting obligations rather than just reporting into the same HR officer or whoever the touch point is under a general grievance policy.
Yeah. Okay, another question for you is, how does this relate to employee or employer responsibilities when working from home? So are there different steps that employers need to take to ensure that they're meeting that positive duty where their workforce is predominantly at home?
And WHS obligations and the obligations under the SDA and Fair Work Act still apply where an employee is working from home. And so it is still important to take reasonably practical steps in relation to that. And what's reasonably practical doesn't mean that an employer is going to be able to prevent this conduct occurring in all situations. But a good example of a step that can be taken in relation to employees who are working from home is ensuring that they always have an available contact within the organization that they can get in touch with if there has been an issue. Often employees at home are a bit more isolated, and so they might be less ready to make a complaint. And so it's also important for managers and other people to maintain good, ongoing, open contact with those employees at home to ensure if there is an issue that they'll be comfortable raising it, even if they're not in a physical workplace at any time.
Yeah, definitely. And that goes back to the culture standard as part of the framework as well. Another question that we have for you is, what are the implications for small businesses and NFPs?
Yeah, and so the same point stands in relation to what I've just said about things being reasonably practicable. And that necessarily is at least in part determined by the size and sophistication and resources of the organisation. And so there's not an expectation under the legislation or from the regulator that there's going to be, the same response or positive action taken by a small business or a not-for-profit as there would be by a multinational. And so for a smaller business, some of those key points we mentioned, like ensuring there's a policy and training, might be sufficient. But that's obviously going to differ for very large companies, and it might be that they're expected to have different training for managers and employees, and that they're collecting data to make sure they're aware of any trends in conduct that occurs. And so really it is about considering what resources does our business actually have, and how can we actually address it in a reasonable way. Great, and I think that's all the questions we have through, Amelia.
Yeah, that's right. Thanks, Joel.
Okay, great. Well, we'll wrap up now, and thank you all for attending. And like we said at the beginning of the presentation, if you could please submit your details in the survey at the end, you'll be able to learn more about our membership. We'll be able to have that complimentary consultation with you as well. And we really appreciate any feedback you do have for us as well. It'll only take about 30 seconds to complete, so we'd love it if you could do that. And thank you for joining us this morning, and we hope there's some positive steps that you can take within your businesses to be able to take off of today's presentation.
Thanks, everyone.